I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, I'm bringing you compilation number 123. And today, because of the length of these appearances, we will be in only two judges' courtrooms on today. Before I give you the rundown on those judges, don't forget to like, comment, share, and subscribe. Also, chapters will be added to this video, even though it's only two judges, for your convenience. Now, the judges' courtrooms that we will be in on today. First, we will be in the courtroom of Judge Chris Morales out of the state of Texas. And second, we will be in the courtroom of Judge Anna Marie Anzelone out of the state of Michigan. And what I am going to do for the Judge Anzelone's appearance is I'm going to leave my previous commentary in that particular video for you guys because I felt that it was relevant and that it was important that I did so. So without further ado, guys, let's go ahead and jump into 123.
Mr. Davis Bay, can you hear me? I need you to unmute yourself.
Yes, sir, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime that took place prior to the unlawful traffic stop. Okay, the state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis as this to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. For one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. An injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, well, I'll just repeat what I said. So this situation happened from an unlawful traffic stop without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021, approximately around the time when the case was first initiated. I did upload and file on record evidence of that notice of rejection as an exhibit. Also, I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for a broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest or search without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also the adjoining case that was with it was a possession of marijuana, which was dismissed prior to even we having these hearings. Okay, I'll continue on. Failure to uphold due process requirements. Okay, due process under the 5th and 14th Amendment requires fair treatment through the normal judicial system. Due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 15.05, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report. And it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits and as a brief.
Allegations made by the state were not contained in the defendant's motion.
Agreed. Sustained. Move on, Mr. Bay.
Okay. Also, the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed. Case dismissed under the fruit of poisonous tree doctrine, and that's Wong Sun versus United States, followed by citation. This doctrine.
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
Yes, ma'am. Yes, sir. Wong Sun is W-O-N-G, first name, last name Sun, S-U-N. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrests, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this matter be dismissed for the reasons stated before.
All right, Mr. Bay, thank you. Your time is up. Your 10 minutes. State, quick question before you respond. Has Mr. Bay had access to discovery in this case? He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was.
Will you spell that, sir?
Last bayby@gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did you request it? Who did you request it from?
The Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by the defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge. Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, Defense was provided copies of all the media, Your Honor, so he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That, in and of itself, constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
I object, Your Honor.
Give me your legal objection.
The prosecutor has failed to mention any case law support his allegation with his brief or anything.
The case law in support of that was in the response to your motion, defense.
Yeah, it was, Mr. Bay.
Can you please
Case law makes it clear the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer v. State, Rocha v. State, Isaac v. State, and then he even cites additional case law, Cameron v. State. So it is cited in there, overruled. Continue.
Based upon the odor of marijuana, a probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time defense or the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate. So he's claiming he has not had he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E v. State. Citation is 593 Southwest 3rd 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
Oh, yes.
Similarly, I also have Lewis v. State. Citation is 532 Southwest 3rd 423. In Bourne v. States, the court makes it clear that arguments such as those the defense is making are sovereign citizen style arguments, which have roundly been rejected by all the courts, all sister courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case, rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the filings made by the defendant, and that one of two things is either occurring. Either the defense is filing frivolous motions to delay the judicial process and attempt to coerce the state into dismissing these charges, or alternatively, the defense is unfamiliar with the judicial process. If the latter is the case, the state would be concerned if the defense wasn't provided standby counsel. That's what Lewis v. State is about, Your Honor. Obviously, it is up to the defendant and it is up to the court, or the court's discretion, rather. If the defense is going to claim that he's having a bunch of rights violated, I would want to guarantee that we protect these rights as strongly as possible. Again, if the defendant were so inclined, by perhaps appointing him standby counsel.
Anything further?
I have nothing further orally, Your Honor. I've made my points in my response to the defendant's motion. Again, this court unquestionably has jurisdiction per the Texas Government Code, as well as the court, or the Code of Criminal Procedure. Additionally, based upon the case law I provided in my written response, as well as orally on the 7th of this month, I believe the case law supports the further prosecution of these cases.
All right. Mr. Bay, although you have used your 10 minutes, I will permit 1 minute of rebuttal.
Thank you. First thing I want to address is the due process of that was violated. The prosecutor mentioned that I had a probable cause hearing at the time of the bond. That wasn't the hearing that I alleged that was a violation. I never received preliminary hearing. Never even entered a plea of guilty or not guilty. That hearing had never happened. We initiated this case back in, bond was filed in March 10th, just looking at the docket sheet, Judge. March 10th, 2021, bond was filed. A hearing for the initial preliminary hearing was not called. The complaint was not even filed until April 27, 2021. So that was a whole 2 months after I was even released on bond, before a complaint was even filed, and no hearing was ever scheduled. A hearing was scheduled for, I'm looking at the docket sheet, a hearing was scheduled for 7/23/2021. It was 2 hearings because at first it was 2 judges. Christopher Morales, and another lady judge. Her name was, and excuse me if I don't have her name right in front of me. But the other case was counseled. The cases was at the same time. So one case was counseled, the other case, I guess, was still heard. And that's when the warrant was issued. But that hearing, we never had a rescheduling that hearing. Once I was arrested again on the warrant and bonded out, that hearing never took place.
Okay.
Also, okay.
That was 2 minutes, actually. So,
All right.
I'm ready to rule. And then I have a question for you as well, Mr. Bay. So I'm going to deny your motion to reconsider. We're going to proceed with trial. And sounds like my understanding, you have had access to the discovery since October 19th. However, he is going to resend everything to you for you to review. My question to you, Mr. Bay, is would you like standby counsel to advise you during trial? They cannot ask questions of witnesses or assist you in that way in the trial, but they can provide advice to you to help guide you through the process.
Yes, I'm not waiving any right to counsel. I do reserve my right, Sixth Amendment right to reserve.
So you've already
standby
waived your right to
counsel.
counsel. You stated you wish to waive your right to counsel and you wanted to represent yourself. We had a whole hearing on that, Mr. Bay.
Okay, so you asking me, do I want to?
I'm asking you if you've stated you want to represent yourself, Mr. Bay. Okay, we had a whole hearing on that. You waived your right to court-appointed counsel, and you stated you wanted to represent yourself throughout this hearing. And I have confirmed that in almost every hearing that we've held in this case. Now, what I'm offering at this point in time is you can still represent yourself in this matter, but the court would appoint a standby counsel who could advise you during the trial. They're not going to participate in the trial, meaning they're not going to ask questions of witnesses. They will not conduct voir dire, but they will advise you regarding certain legal rights that you may have or on legal matters that may arise during the trial. Would you like the court to appoint you a standby counsel?
Yes.
Yes. So you are asking the court, I just want to confirm, you're asking the court to appoint you an attorney who will provide you advice through the course of your trial, which shall begin on December 3rd.
And I also request that I reserve all my rights. Yes, that's a yes to that question, and I reserve all my rights.
Well, you waived your right to court-appointed counsel already with that whole hearing we went through. But I'm still giving you a court-appointed attorney to advise you, okay? You understand?
Well, I never waived my right to the Sixth Amendment.
I can have my court pull the record if you like, Mr. Bay, but we're not going to, I'll tell you what. Do you want to continue to represent yourself?
Yes, I answered your question. Yes.
Okay. Well, you're stating that you don't want to waive your right. Okay, here's the thing. Do you want court-appointed counsel that's going to represent you during the course of this trial?
Like I answered the question. I said yes, I would take standby counsel, represent myself.
You're going to take, so you still want to waive your right to court-appointed counsel and continue to try this case yourself, but you're willing to accept standby counsel to provide legal advice only during the course of the trial. Is that correct?
Correct.
Okay. All right.
What's your name?
I'm here representing Brian Musgrove.
You're Brian Musgrove?
I'm here representing.
I have no idea what that means. So why don't you come up to the podium?
I had tried to.
Nope, yeah, stand in front of the thing. So what is your name?
Brian Joseph Musgrove.
Okay, are you an attorney? What's your P number?
I'm not an attorney.
So then you can't represent Brian Musgrove. So
I'm
you are a defendant,
I'm
correct?
an executor on that estate.
Okay, so none of that is valid or legal. So you have an attorney?
He's not doing nothing for me.
Okay, that wasn't my question. Do you have an attorney? Yes or no?
I have, yeah, he was supposed to be representing me, but
So you have Michael Dagger Margosian. Okay, so he's your attorney. Okay, so go have a seat. When Mr. Dagger Margosian gets here, I'll call your case, okay? All right, so Mr. Musgrove, you want to come up to the podium, please? This is in the matter of the people of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Isaac Sneed appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of Mr. Musgrove. Mr. Dagger Margosian might, oh, there he is. So, Mr. Dagger Margosian, this is a date and time set for pre-trial in this matter. Mr. Musgrove said that he was appearing on his own behalf. I did verify he is not an attorney, and you are still the attorney of record. So, Mr. Dagger Margosian, how do you wish to proceed?
Well, Your Honor, I am aware that Mr. Musgrove wants to present information to the court. I'm happy to be standby counsel if he wants to represent himself. Obviously, this court would have to go through the colloquy of that, but obviously it's Mr. Musgrove's legal right to at least ask the court to do that. So I'm here to observe at this point.
All right. So, Mr. Musgrove, when you were at the bench or up at the podium before, you said that you were appearing on behalf of yourself. So, Mr. Musgrove, are you asking to no longer have counsel represent you?
Well, what I'm understanding is that the court is a private for-profit.
So, Mr. Musgrove, I know where you're going with this, and none of that is valid. None of that is law.
I'm not the all caps name. Of course.
None of that is valid. None of that is law. You are standing in my courtroom. I have jurisdiction over you. So.
I tried to file paperwork with the clerk's office ahead of time so that you would have time to review it, and they denied me.
I know what you're talking about. None of that is valid under the law of the state of Michigan or the Constitution of the United States of America.
What do you mean it is?
No.
The Supreme Court says it is.
What does it say it is?
The Supreme Court says that if we were at the age of 18, we were supposed to claim our minor status.
Nope, not valid.
Okay.
So here's what I would say to you. Mr. Dagger Margosian is, like most of our public defenders, exceptional attorneys and very well versed in the law and very experienced. He gives legal advice. You may not like the legal advice, but it's usually good advice. I've never had anyone from the public defender's office not wholeheartedly try to represent their clients. So what you are talking about is not valid, and it is not going to get you out of this case. You're not going to be able to say all those things because it's not valid.
Everyone involved in this court case has a financial interest in the case.
I don't have a financial interest in your case. I get paid by the state of Michigan, whether you plead, whether it gets dismissed. I don't make any money off you. We have budgets. The court system is not a profit generating revenue. We are here to represent people so that people who are charged with crimes are protected. People who are victims of crimes are protected. And that's why we have.
In order for there to be a crime, there has to be a victim. There is no.
Well, there is a victim in this case.
The victim would be the company.
You are charged.
I can't face.
Actually, just hold on. So your crime that you are charged with, which you are innocent as of this time, let me grab the right file, is failure. Oh, this is let me see. This is an embezzlement charge. So you are charged in count one with embezzlement 50,000 or more, but less than 100,000. That being an agent, servant, or employee of Hardwoods of Michigan Industries did convert to your own use without the consent of your employer or principal industrial tools and equipment in the amount of $68,938.40 or money or equipment. And that's a 15-year felony. So if you are found guilty by a jury, you can go to prison for up to 15 years. You're charged in count two with using a computer to commit a crime. To facilitate the charge in count one, that carries a maximum penalty of up to 10 years in prison. And the way the statute is set up, I can actually stack those possibly. So you potentially could be looking at up to 25 years in prison. So the victim that's alleged in this would be that business.
Right, and I can't face that accuser because that business can't get on the stand for me to ask questions. And a third party.
But their
can't stand
representative
it.
can. Yes, they can. Yes,
They
they
can?
can. Yes, they
Okay.
can. So I have 189,000 of student loan debt that was forgiven to be a lawyer. You do not. And Mr. Dagger Margosian, Mr. Isaac Sneed, all of the attorneys here went to law school to know the law, and their job is to advise you of the law. So
Yeah,
yes,
but
they
they're
can.
going-
Yes,
They're
you
going
can be
by
charged.
everything,
You
all the
can't-
laws and statutes that you guys go by
Are
for
legal.
corporations. They're for fictitious.
Still a crime. Still a
corporations.
crime.
But I'm not
Still a
a fictitious
crime.
corporation, I'm a living person.
Yep, and that's why you're
Okay.
standing in front of me. If you were dead, the case would be dismissed.
Woo, guys, I had to just stop it really quickly right there. And I promise I won't stop it anymore after this. But did she just say to him, if you were dead, then the case would be dismissed? Listen, this lady is not messing around with our boy Bryant. And when he kept saying it's a corporation, she was like, still a crime. Still a crime. And think about what she's saying. She's saying basically like, whether it's a corporation or not, you still did the crime. You still need to be held accountable. Wow. Listen, Judge Anzelone, I'm glad we are here in her courtroom today because she definitely does not play. And this is going to be interesting how the rest of this plays out. I promise, guys, I'm not going to jump back in anymore.
Yeah, the all caps name is that.
That means nothing. That's not valid.
Okay.
It's not legal.
right.
So do you want to represent yourself or do you want to have an attorney to represent you?
I need some time to think.
Okay, so I'm gonna set this for another pretrial on March 20th at 8:30 in the morning. And Miss Adams, could I get a notice of hearing for Mr. Musgrove?
Yes, Judge.
All right, so Mr. Musgrove, have a seat on that bench right behind you. And then Miss Adams will give my bailiff a notice of hearing, and my bailiff will provide that notice of hearing to you. All right, now we got Mr. Musgrove. Let's see where he is. Mr. Musgrove, you want to come up to the podium now? This is in the matter of the people of State of Michigan versus Brian Joseph Musgrove, file number 23-21461F8. I have Isaac Sneed appearing on behalf of the people and Michael Dagger Margosian appearing on behalf of Mr. Musgrove. This is the date and time set for a pretrial conference in this matter. So Mr. Dagger Margosian, how do you wish to proceed today?
Your Honor, Mr. Sneed and I have reached a resolution in this matter. Mr. Musgrove will be pleading guilty to 2 counts of LIB, and in exchange for that, the original counting information will be dismissed.
I'm sorry, he's going to plead guilty to 2 counts of what?
I'm sorry, LIB, larceny in a building. And I don't know if there needs to be an amended information.
I have a count 3 larceny in a building, so I only have 1 larceny in a building, so I think they'll have to amend the information to add a count 4
Okay.
larceny in a building.
Okay, and then
He's pleading to 1 count of larceny in a building. Is that correct?
that's
I
fine.
mean,
That's
we
fine.
discussed it, but I learning this morning that he's pleading. So
1 count or 2 counts?
Mr. Sneed,
I thought we discussed pleading to count 3,
one
so we
count of
don't need an amended information.
beautiful. One count of larceny in a building. Count 3.
All right, so just count 3. Okay.
And then additionally, Your Honor, there's an agreement for no MDOC and no upfront jail, and also that the amount of restitution will be paid back over the course of probation, which would be ordered anyway.
Okay. And then count 1, 2, and obviously the habitual offender 4th offense notice will be dismissed, right?
Correct.
All right. Mr. Musgrove, you want to raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Now, I'm going to need you to speak up a little bit. You're soft-spoken. So, Mr. Musgrove, you've heard the agreement that was placed on the record. Is it your intention to plead guilty to count 3, larceny in a building? That offense does carry a maximum penalty of up to 4 years in prison and or a $5,000 fine, but there's an agreement that there would be no prison term and no upfront jail.
Yes, ma'am.
So is it your intention to plead guilty to that?
Yes.
Now, you've had an opportunity to meet with your attorney and discuss this plea. Are you satisfied with Mr. Dagger Margosian as your attorney and the advice that he's given you?
Yes.
All right. Neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any other possible sentence with the court. Is that correct, Mr. Sneed?
Well, Your Honor, we did agree upon the restitution being set in the amount of $21,660, I believe. Other than that, no.
All right. Is that correct, Mr. Dagger Margosian?
Yes, Your Honor.
Okay. And you understand that?
Yes.
Okay. And you would have the term of probation to pay that off. Okay. Anything else, Mr. Sneed?
No, thank
other
you, Your Honor.
discussion. Mr. Dagger Margosian?
No, Your Honor.
Okay. And would you agree with that, Mr. Musgrove?
Yes.
All right. So if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that? If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, ma'am.
So, how do you wish to plead to the charge that on or about June 21 of 2023 in the village of Clinton in the county of Lenawee that you did commit the offense of larceny in a building? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No.
Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Sneed?
No, thank you, Your Honor.
Mr. Dagger Margosian?
No, Your Honor.
Has your attorney, other than the agreement that was placed on the record, promised you any particular sentence or estimate what your sentence will be in terms of fines costs?
No, ma'am.
All right. Is it your own choice to plead guilty?
Yes.
All right. So, Mr. Musgrove, on June 21 of 2023, were you in the village of Clinton in the county of Lenawee?
Yes. Oh, no.
And
June. What day?
with June 21 of 23 during that time period, on or about? All right. So, Mr. Dagger Margosian, perhaps you can.
Yes or no?
Okay.
Voir dire.
Mr. Musgrove, just like the judge had asked, on June 21st of 23, were you in Clinton, village of Clinton, county of Lenawee?
No, I was already terminated from employment at that company on May 5th. I wasn't there after that. The charges came after June.
All right, so on May, Mr. Sneed, any objection to amending it to May 5th?
No objection.
Mr. Musgrove, on May 5th of 2023, were you in village of Clinton, county of Lenawee?
Yes,
Okay, and on that date, did you enter a building, specifically Hardwoods of Michigan facilities?
yes,
Okay. And did you take property from that company without their permission?
yes,
Okay. And it was, I mean, it was multiple items, true?
yes.
Okay. I guess I'm satisfied, Judge.
Mr. Sneed, are you satisfied?
I am. Thank you, Judge.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. Sneed,
Yes, it has.
Mr. Dagger-Margosian?
Yes, Your Honor.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. And Ms. Adams, could I get a notice of hearing from Mr. Musgrove for his sentencing? I'm going to set this matter for sentencing on May 23rd of 24 at 8:15 in the morning, and I'll get you some paperwork today to take with you.
Okay.
Do you want to come in person or via Zoom?
I can do it in person, it's fine.
Okay, so we'll do that in person. And that will be at 8:15 on May 23rd. I'm going to send you, once you get your notice of hearing, I'm going to send you across the hall to the probation department. They'll give you a packet to fill out and they'll set up a time for you to meet with them. Make sure you meet with them and fill out the packet and then be honest with them about your background and the events that occurred. They'll prepare a report. We'll get a copy to Mr. Dagger-Margosian. Call him about a week before or so to review that with him.
Okay,
And then we'll see you back on that day for sentencing in person, okay?
okay,
All right, so I have a seat right behind you on that bench. And then we'll get you that notice of hearing. Thank you, Mr. Musgrove. This is in the matter of the state of Michigan versus Brian Joseph Musgrove, file number 23-21461FH. I have Phoebe McClure appearing on behalf of the people and Michael Dagger-Margosian appearing on behalf of Mr. Musgrove. This is the date and time set for sentencing. Mr. Dagger-Margosian, you did receive a copy of the pre-sentence report.
Yes, Your Honor.
And Mr. Musgrove, have you had an opportunity to review this with your attorney?
yes.
All right, so I need you to kind of scoot closer to the microphone and I need you to speak up loud so that when we're recording this for appellate purposes, that it shows up, okay?
Yes,
All right, so, and you've been able to speak with your attorney and discuss it?
yes,
Are you satisfied with Mr. Dagger-Margosian as your attorney and the advice that he's given you?
yes.
Mr. Dagger-Margosian, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No,
All right. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
none to my knowledge at this time.
So I show that the probation department has calculated the minimum sentencing guidelines to be 7 to 23 months. You agree with that calculation of guidelines?
Your Honor, I don't have any challenges.
Okay. So Mr. Dagger-Margosian, I would also note that at the time of the plea, the prosecutor agreed to no initial jail or prison and restitution was determined to be $21,660, and that's what was placed on the record. And of course, the court will follow that agreement. But before the court passes sentence, do you have, you're not really on this case, but I called your name. Do you have anything to say on behalf of people?
No, but let me, I guess, check if anyone's here on it. No.
No,
one's
no?
here on it. Thank you.
Okay. Mr. Dagger-Margosian, is there anything you'd like to say on behalf of Mr. Musgrove?
Your Honor, we additionally received the victim impact statement. We've reviewed that. There's nothing substantive that we need to address in that letter. As the court kind of just indicated, I would just ask the court to follow the recommendation of probation with the order of restitution to be paid over the course of probation and to follow the sentencing agreement for no upfront jail. Obviously, that gives Mr. Musgrove the best opportunity to make whole on that restitution. So I think that would be in the best interest of everybody, and I would just ask the court to follow the recommendation.
All right. Mr. Musgrove, anything you want to say in your own behalf?
No, ma'am.
All right, so in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and the protection of society. The sentence of the court will be placed on probation for a period of 3 years. I'll give you credit for time served of 6 days. There is restitution in the amount of $21,660 payable to Hardwoods of Michigan. During the term of probation, you will obey and comply with all the articles of your probation, but some of them will be that. So. I don't see any alcohol offenses, so I'm not going to order the term that you cannot consume alcohol. I am going to order that you can't use any illegal controlled substances and possess any paraphernalia. You must use all prescription drugs only as prescribed. Have any assessments done as required. Complete any counseling they refer you to. Not have or use any object as a weapon. You must submit to search of your person and property, including but not limited to your vehicle, residence, computer, phone, without need of warrant if they feel they have reasonable cause to believe you have items that would violate the terms of your probation. So does that mean $605 a month? Ms.
Yeah.
Holly? Okay, so what I'm gonna have Ms. Holly do is she'll set up a monthly amount you must pay towards this to make sure that by the time your probation's done, you've paid it in full, okay? So, and you must do execute a wage assignment when you're employed and not miss any payments. There's a crime victim rights assessment fee in the amount of $130. Like I said, restitution in the amount of $21,660. There's a $30 per month supervision fee, $60 if we have to put a tether on you. I don't think that would be a problem. $750 in court costs. There's $450 in attorney fees and $68 state costs. No $60 DNA fee, I think, because he's had it done recently.
Correct.
Okay. So, anything else, Ms. Holly?
No.
Okay. So, Mr. Musgrove. My bailiff's going to hand down to you your notice of right to appellate review. We're going to have you initial and date one copy to go in my file just to acknowledge you received the paperwork, okay? The other copies are for you, and if you wish to appeal the sentence, you would fill out the information on the form and mail it to the address list on the form within 42 days, all right? Okay. And do you want him to chat with you today?
Tuesday between 8 and 10.
Okay. All right, so Mr. Musgrove, Ms. Holly, I just need you to report to her Tuesday between 8 and 10. Is that all right?
Yes.
Okay, so good luck to you, and the record should reflect I've received back a signed copy of the notice of right to appellate review. Thank you, Mr. Musgrove.
Thanks.
Well, there it is, guys. We have come to the end of the court proceedings for Mr. Musgrove. And as you can see, all three appearances before Judge Anzelone was very interesting, including the last one, his sentencing. But if we notice from the first appearance, he came in definitely with his sovereign citizen head on. He definitely came to play the game. But Judge Anzelone, being as seasoned as she is, she just wasn't playing the game. And, he went in to say, oh, attorney Margosian isn't doing anything for me. And if you go back to that video when attorney Margosian was there listening to him say that, he didn't have any facial expressions. He still was willing to be there for him and to help him out. And as we see these appearances progress, he absolutely did that, right? Somewhere along the line, Bryant came to his senses and said, listen, I'm going to go with my attorney. The attorney was able to get him to probation. Obviously he got to pay that 20,000 wow that he owes, and hopefully he does that over the course of his probation. But, it seemed to work out for him, at least with all the embezzling that he did and stealing, that he didn't have to do, any jail time. And some of you out there may be saying, oh, we don't know what the company did to him. We don't know why he did it. And that's a fact, right? The company could have been terrible to this guy. They could have treated him wrong. But at the end of the day, stealing is stealing, right? Like, you have to be held accountable. I mean, at the end of the day, if they did do anything wrong to him, he could have went, got another job, seeked other employment. But this is what he decided to do. And we're not saying that that's what happened. He could have just been stealing, right? Like, we don't know. But at the end of the day, if something was done to him wrong, that still doesn't give him the right to steal. It's just like being in a relationship. If somebody cheats on you and does you wrong, that don't mean that you have the right to turn around and kill him, right? Because at the end of the day, you're still going to be held accountable for your actions. You're better off moving on, finding another relationship, and showing them that, you're a better person than them. But with that being said, enough of me talking, guys. We're going to get ready to get out of here. Know that I appreciate you guys. Don't forget to like and subscribe to the channel. And until the next time we court hop into another courtroom, know that I appreciate you guys. God bless. See you soon. Peace.